Hi, I'm Commissioner Raquel Regalado. Thank you for joining us on your lunch break. Today, we're talking with one of our amazing community partners about the different programming and opportunities that we have and how we work with them and how we can work with you to do more and provide these services to all the residents of Miami-Dade County.
Well, welcome to today's educational webinar from Commissioner Raquel Regalado's office. My name is Alejandro. Today, we're partnering with Legal Services of Greater Miami to talk about eviction services, what that means, and the services around that. And for that, we have Alexis and Blake. Thank you for joining us.
Thank you so much, and thank you to the commissioner for setting this up. We are so excited to be here. We've actually never done a webinar before, so this is a really cool opportunity to reach the client community. So my name is Alexis. I'm a staff attorney at Legal Services of Greater Miami in the Tenants Rights Unit, and I'm here joined by my colleague. I'll let him introduce himself.
I'm Blake Wallace. I'm also a staff attorney at the Legal Services of Greater Miami. So it's great to be here, and I'm excited to talk about this with all of you.
Perfect. So I'm going to share screen and just let me know um, if it's working.
Looking good.
Looking good. Okay. So, this we're going to talk today about tenants' rights, what that means in the state of Florida. We're going to talk a little bit about security deposits and like Alejandro said, we're going to save some time at the end for any questions that you guys might have. So, here you'll see legal services partners with a lot of community organizations like the commissioner and these other organizations, all in the effort to enforce and protect tenants' rights in Miami-Dade County and Monroe County. Okay. So, what we're going to go over, like I said, we're going to start talking about what evictions look like, the process of it. So, evictions start with a notice. It has to be a written notice. Once that notice expires, then the landlord can file an eviction complaint. A complaint is just a lawsuit. Once that complaint is filed, that is when the tenant has to file their answer and raise their defenses in court. Those defenses should also include what's called a motion to determine rent. Um, and then we're going to talk about protections and just the overall eviction process. So that's what we're going to talk about generally today. We'll start with the goals of eviction diversion. The goals of our unit and what we like to focus on is first and foremost keeping families in their home. Our priority is safe, stable housing for individuals and families who are facing evictions. And if we're not able to keep families in their home for one reason or another, then our next priority is going to focus on allowing families time to relocate into other safe and stable housing. Um, the other priority we have is to avoid getting eviction judgments on people's records, keeping families out of the homeless continuum of care. Um, when you have an eviction judgment on your record, it can be a little harder, much harder to secure new housing. And so it is a huge benefit that if we can, we'll at least try and maintain clear records for people so that they can still find future housing. And then we just acknowledge that the cycle of evictions can be very vicious and it traps people into poverty and other issues of instability. And it has more collateral consequences. So, with evictions, we're talking about homes, and your home is more than just four walls. Your home is where your kids go to school, how close your doctor's offices are. And so we try and do everything in our power to maintain home stability as much as possible.
So we also are here to talk about the law. Obviously, that's why we're all here. So the Florida Residential Landlord Tenant Act is Chapter 83, Part 2 of the Florida statutes. You can actually Google that yourselves. Honestly, if you just Google Chapter 83, Part 2, it should be probably the first Google search that comes up. One thing is, I just want to clarify this presentation. So what we're talking about today does not cover the additional laws and rules that protect tenants living in subsidized housing. That's things such as, public housing and Section 8 housing. Chapter 83 does apply to anyone that rents a dwelling unit. So, apply if any of you are renting, it applies to you. It applies to myself as well. So it does not apply though to those who are in transient occupancy. So, if you're residing in a hotel, a motel, or a rooming house, um, it also does not apply to, residents in uh, any location that's a prison, a nursing home, school, dormitory, or facility. So this is kind of residencies where you're living there, but it's incidental to the provision of services. So the services come first, your residence comes second. And then it also doesn't apply to mobile homeowners. So those who are renting a lot. And when I say renting a lot, I don't mean renting a mini, I mean renting a place for their mobile home to be located on.
Right. And then just to be clear, legal services does offer and take cases about transient occupancy. You might hear it called unlawful detainer. That's just governed by a different chapter. We also will assist in cases about mobile homes. It's just that here, residential landlord tenant evictions fall under chapter 83. But if you are facing issues, housing issues that are not under this chapter, you can still come to us and we'll still provide advice and services.
So, when it comes to the rental agreement, it's commonly thought that agreements have to be in writing. They do not. All that needs to exist between two parties for a contract. So in this case, the rental agreement is something called a meeting of the minds, which can be as simple as a handshake agreement between parties. So the agreement can be either oral or written. Um, One thing we do have to say is a written rental agreement or a lease is usually better. That's just because it helps to better define the terms of the agreement. And, a party can't, we want to say everyone's truthful, but in reality, not everyone's truthful. So it's usually better to have it in writing. These agreements should cover things such as what is the rent and what does the rent cover. Um, when it comes to what the rent covers, that can include things such as utilities. So, water, electricity, internet can be included. So those are things that it should cover. It should cover what's the term of tenancy. So we see tenancies that range from, yearly tenancies, so 13 or 12-month tenancies, to month, which just means you're renting each separate month. And then it also speaks to the obligations of the parties. So it speaks to what the landlord is responsible for, such as any repairs that they need to make if something's not working, and then what the tenant, so the person who's renting, is responsible for. So whether it be cleaning the property or maintaining small things such as uh, on your air conditioning unit, changing the vent every 3 months. Because I know we live in South Florida, so we're all using air conditioning all the time. So that's something that the agreement should cover.
So next, we're going to talk about the different types of evictions. The most common type of eviction is for the non-payment of rent, which is simply that the landlord says, "Hey, you haven't paid the rent. We'd like you to vacate." But there are also different types of evictions, like lease violations. A lease violation might be like you have a dog at the premises that shouldn't be there, or you have someone who's not on the lease living there. So that could be the basis for an eviction as well. The termination of a month-to-month tenancy, Blake just kind of touched on. To terminate a month-to-month tenancy where your tenancy is renewed every month that you pay rent, to terminate that relationship still requires a notice, and even at the end of the lease term. The point of this slide is to tell you that regardless of the type of eviction, for any of these reasons, they all require written notice. And that's really important because that is how the eviction process can properly be started. So it's important that if your landlord is telling you verbally, "Hey, you need to leave at the end of the week," well, that's not written notice. And so that's not proper. That's not the proper start to an eviction. So, like we just talked about with the different types of evictions, they require different notice periods. So for that non-payment eviction, the landlord is only required to give you a 3-day notice, meaning that you have 3 days, not including weekends or holidays, to pay the rent as they allege in that notice. For a lease violation, it's a 7-day notice. There are two kinds of lease violation notices. Both are for 7 days. For major types of lease violations, like let's say there's been criminal activity that you're being accused of, that would not you would not be given the right to cure that if it's something called a material or a major lease violation. But if it's something like a dog, that's not that big of a deal. That we would say is a minor lease violation where you would be given the opportunity to cure it. And so in that instance, you would be given a 7-day notice to cure. Whereas in the major or material lease violations, you would be given a 7-day notice with no opportunity to cure. And then as far as the month-to-month tenancies, you have to be given a 30-day notice before the landlord can terminate your month-to-month tenancy. You should also be given a certain notice at the end of your lease if your lease expires. Now, those are typically dictated by what is in your lease, which is why it's really important to have those written terms to see what the parties are required to give. And then just importantly, your lease can only expand these requirements. They can never reduce them. And so what we're talking about today is the floor. These are the minimum requirements that landlords are required to follow. So they can always give you more time. They can never give you less time.
So when it comes to filing the eviction complaint by the landlord, it will be filed in county court. One thing that you need to know is that the court in which the action is filed will depend on where the property is located. So, if you're located in North Dade, the court, the landlord will have to file in North Dade. They aren't able to say, "Oh, well, you live in North Dade, I'm going to go file in South Dade or Coral Gate." Um, Usually, our complaints come in to either one or two counts. One count is the landlord is asking for possession only. They're not asking for damages at that point. And by damages, I'm speaking about unpaid rent. They're speaking about damage to the property itself. So, say the C unit was destroyed or something like that because a kid ran into it. That would be damages action. When it comes to answering the complaint, um, you can actually file your answer at any one of these locations. So you don't have to file. So if you're located in North Dade, but you work downtown and you're dealing with a filed complaint in North Dade, you can file your answer downtown. You don't actually have to go to the North Dade location to file your answer. When it comes to service, this is also dictated by a statute. We listed the statute here for you guys. It's 48.183. It's when you are served, you have to be served in one of two ways. It's either by personal service or by posting. They have to try two separate times for personal service. It has to be over 6 hours apart when they make those two attempts. And then they're able to post at the location. Now, when you get mailed a copy by the clerk, just so you know, that is not service for purposes here. That is just the clerk is mailing you a copy of the complaint itself. So the landlord is required by law to either serve you personally or post it on the property. And when they post it on the property, they can't, hide it behind some bushes or something like that. It has to be placed in an inconspicuous place. So it has to be front. What you often see is it posted front and center on the front doorway. That's what they need to do to affect service.
And the reason that this is important and why understanding service, proper service is important is because once you are served, that starts the timeline of events of when you have to answer. So once you are served, either through personal service, which is I hand it to you, or the posting of it, you have 5 business days to go and file your answer at one of these county court locations. So that's why we say make sure as soon as you find out that you have a notice, or certainly when you're served, come to our office so we can talk to you about where you're at and what's going on. Oops, sorry.
So when you are served, it'll look something like this. And when I say something like this, it most likely will look exactly like this. The only difference is you will know that you are being served because there will be a big red stamp on the document, basically saying that you have been served. Um, so you'll be given this form. It's just the standard summons form for the county of Miami-Dade. And once you get this, just like Alexis previously said, come to our office. We're here to help. That's what we're here to do. And, we can walk you through what action needs to take place in terms of responding to the notice that was given to you.
And as you can see on this service form, they will check off the location that is closest to your home. So they'll tell you where you can go file it. But like Blake said, if the property you live at is in North Dade, but you work in Hialeah, the tenant, can go and file in Hialeah. But the landlord is required to initiate this action in the court that is closest to the property. So once you're served, like we said, you have 5 days, excluding weekends and holidays. So I want to back up and just make sure we kind of know where we're at in the process. So at this point, this is when you're filing your answer. So you were given a notice. Let's say it's a 3-day non-payment notice. Once that notice expires, the landlord can then file the lawsuit or the complaint. Once they get the complaint, they then have to serve through posting or personal service. Once you are served, that is when these 5 business days kicks in. So the best way to think about it is if you are served on a Monday, your answer is due the following Monday, unless like last week we had Juneteenth. So if there's a hot court holiday, you push it one day. So for this week, people who were served last week, they actually have one more day to answer because the courts were closed on Juneteenth. So this is really important. If you remember anything from this presentation, please remember to file your answer within these 5 business days. We strongly, strongly encourage you to go in person to file. It's kind of like going to the DMV. You have to get a ticket and file or bring it to the clerk to do that. But if you don't do that, then if you fail to answer or you just kind of ignore it, which is what we see sometimes, the landlord is automatically entitled to that eviction judgment without ever seeing a judge, without doing anything else. So it's really important that, if anything, make sure you file your answer. This is what the online Miami-Dade clerk's office looks like. So this is where you can actually look up your court filing. You can search for it by party name, or if on that summons, this summons, it'll say case number in the top right. You can use that case number and plug it into this database to also look up your case number and see if if your answer had been properly filed, if there's any upcoming hearings, anything like that, or if there's any court orders that you were supposed to follow. So in addition to filing your answer within those 5 days, you're also required to file what's called a motion to determine rent. Well, actually, let me back up. In addition to filing your answer, you also have to comply with Florida Statute 8360. This is what we call our rent deposit statute. Under this statute, you have to do one of 3 things in addition to filing your answer. So under the statute, you can either tell the court you already paid it. So that's what we call raising payment as a defense. That's that middle box here. If you didn't already pay it, you can deposit the entire amount that the landlord says is owed. So if in the complaint, landlord says, hey, you owe me $5,000, you can just deposit the entire $5,000 into the registry. If you dispute the amount the landlord says is owed for any reason, so if landlord says, hey, you owe me $5,000, and you say, no, I only owe you $1,000, then you would be required to file what's called a motion to determine rent. That is fancy legalese for asking the judge and telling them, Judge, I don't agree with what landlord says that I owe. Judge, I would like you to hold an evidentiary hearing where I can show you evidence of my payments where I've only ever paid $1,000. And Judge, I would like you to make a determination of how much rent I owe in order to deposit that into the registry. The reason that this is important under 8360 is because Florida is what we call a pay-to-play state. It means that you have to deposit into the registry before you're able to raise any defenses. So, and this is regardless of the type of eviction, whether the eviction basis is for non-payment or for a lease violation, we have to deposit the amount into the registry as alleged by the landlord or as determined by the court before we can raise any defenses. And in fact, the judge cannot hear any defenses until this statute is kind of taken care of. This statute is about 90% of our cases where it ends right there, because as you can imagine, if our clients and our tenants had the ability to pay the rent, a month or two ago, they would have paid it, right? So this rent deposit statute is really, really hard to get past. But once you do, then you move on to the next phases of the lawsuit. But if not, let's say you don't deposit. Let's say you didn't ask for a motion to determine rent hearing or a rent determination hearing, and you didn't raise any defenses, but you did file your answer. It still doesn't matter. The landlord would still be entitled to that automatic eviction judgment. So that's why it's really important that if you take another thing away from this presentation, make sure within 5 days you file your answer and you do at least one of these three things. So again, you can either raise payment as a defense, where you tell the court, I already paid this. You can deposit the entire amount as alleged, or you file a motion to determine rent. And just so you guys know, that is not a fancy legalese motion. That can simply be 1 or 2 sentence, more detail is better, but it should say, I dispute the amount landlord says that I owe. I think I owe XYZ number. Judge, please hold a hearing to determine that amount. So this is the consequence of failing to deposit. It is a waiver of all of your defenses, and it's an immediate judgment for possession without a hearing, without having your day in court, without seeing the judge. So it's really important that, if anything, these very tight deadlines they're really easy to miss. So just knowing them and knowing that if you just file these things, you've gone much farther than what a lot of our tenants see instead.
One thing I wanted to mention on
Please.
the prior slide is that even though it's an immediate judgment for possession, you can go back one. Yeah.
Oh.
It isn't a judgment regarding damages. So damages
Yeah.
is determined separately. So they run on 2 different timelines, really. So we see possession run on a separate timeline other than damages. But if you fail to comply with 8360 regarding possession, they're given judgment regarding possession. But that still leaves the question of damages open for you.
Yeah. So Blake is right, and I'm so glad that he emphasizes this. A eviction judgment for possession is not a money judgment. So if you get an eviction judgment, there is no judgment recorded against you for the back rent that you allegedly owe. That would have to be a totally separate process, or the landlord would have to have pled that in the beginning, which is the difference between that 1 and 2 count eviction. Thanks, Blake.
So if you need help with filing an answer and motion to determine rent, we do have a sample answer with our most common defenses. It's actually available on our website at www.legalservicesmiami.org/self-help. That's an easy way to, get a sample answer. So, if you feel like you can't necessarily get to our office and get our services in time to answer, and say, you know, you were served 4 days ago and you need to just file an answer, that's a good place to get a sample answer. Most important thing is getting an answer in. If we have to file something called a motion for leave to amend and amend the answer, that is totally fine. But getting the answer in the first place is important, and I can't stress that far enough. Um, there's also the Miami Workers Center. They'll have referral to our offices for legal advice and assistance. So that's another way that you can get help with filing an answer motion to determine rent.
And the last thing I just want to mention is that there are pro se, which means unrepresented by an attorney. There are pro se sample answer forms available at every clerk's office. It is on every clerk's office website. It is on the Florida Supreme Court. This sample answer was approved by the Florida Supreme Court for you to file. It's very easy to fill out. You just check the boxes off for the defenses that you believe apply to you. One of those boxes includes that motion to determine rent, where it gives you a couple lines for you to detail your dispute. This is what
And
that, oh, sorry, go ahead.
yeah, I was gonna say this is what that form looks like. You just go through, check the boxes that apply to you. One thing I can say is don't admit to all the statements of the complaint being true unless you know for a fact they are true. Otherwise, you just go through the complaint, you dispute which statements you believe are fake or false. And then if you do not know, you can check. I do not know whether true or false. Therefore, you're denying them at that point. And then you just go through the entire form. This is just pages 1 and 4. There's additional pages that detail the different defenses that you can select. And then when it comes to requesting a trial, you can request whether or not you want a judge to decide your case or a jury to decide your case. That is up to you. However, just be aware that, everyone, if you let a judge decide it, it's up to that individual judge. When you let a jury decide, it's up to a jury of your peers that are going to be deciding your particular case.
And what I will say is that I actually encourage my clients to choose that you want a jury, because if you choose a jury in the beginning and later you decide you would like the judge to decide, you can make that switch. But if you choose a judge in the beginning, you cannot switch later to a jury. So just keep that in mind. The other thing that's really important, make sure you sign and date in legible handwriting, please, because the clerk is going to use the information you put there for your email address to contact you and stuff like that. The other thing I want to highlight is that for everyone named in the lawsuit, so sometimes, if you're roommates, it's going to be you and your roommate named as defendants. Both people who are over 18 need to sign this answer in order for you to have both complied with filing it. Either both of you need to sign the same answer or the other person needs to file their own answer. So this comes up a lot with roommate situations, or if you're married, you and your husband or your partner, you both still need to sign it to make sure you have both answered. So after rent determination, or after your answer is filed and then rent determination, whether through a motion or a hearing, let's say we get past that. The next thing that happens is the court will probably send you to what's called mediation. Mediation is a process where the parties will meet one-on-one with a neutral third party, the mediator, and they will help assist in trying to get the parties to resolve the conflict instead of going to trial. So in evictions, this is actually a free service. You are given I believe it's a 1 hour free mediation service for the parties to try and come to an agreement. If you don't come to an agreement, hopefully you do, but if you don't come to an agreement, then the next step is that discovery phase. Discovery is kind of that stuff you see on TV where it's like, I want all the papers, I want all the ledgers and the depositions where you ask people questions and stuff like that. That's the fact-finding investigation phase of this to determine, do I really even have someone who's unauthorized living in my property, or how did the landlord know that? Once that happens, then after the discovery phase, you're going to move to the motion to dismiss, where you're going to ask the court to dismiss the action based on other legalese that we don't have to get into today. If your motion to dismiss doesn't work, it's denied for whatever reason, then you're headed to trial. And the trial on the eviction is going to be based on the defenses that you raised in your answer. And so I want to be very clear about this. What you put in your answer, I want you guys to be very, very intentional in your wording and make sure that you are raising, as much as you can, defenses that dispute the actual eviction. So a lot of things that we see is people asking for more time, or people saying that they're trying to work things out. That's not really a legal defense that the court can kind of rule on. You're really asking for the court's leniency, which the court can certainly consider, but it's not really a strong legal defense. So if you can, try and put as much detail as you can, which would dispute what the landlord is saying you owe, or what the landlord is alleging in that eviction. At the end of the trial, this is what you see on TV, where the plaintiff landlord will make a presentation, the defendant tenant will make their presentation, and at the end, the judge will make a determination as to whether the eviction judgment will be entered. If you win, you get to stay at the property. That's the end of the trial. If you lose, unfortunately, then you'll move on to what we call the writ of possession process, or the eviction process here. The writ of possession process it can only happen if you got that eviction judgment. So whether you got that eviction judgment from losing the trial, or whether you got it for earlier for failing to do the rent deposit, the final judgment must be entered first. Then the clerk will issue what's called the writ of possession, which is fancy Latin legalese for the court is giving possession of the property back to the landlord. You will see in the court docket when that is issued. That's why it's a really important source to be able to find your online docket. Once that writ of possession is issued, then the sheriff's office will post a 24-hour notice on the tenant's door. Once that is posted, then the sheriff can return after the 24 hours has expired to remove whoever is in the unit. The reason that this is important is because there is no exception for weather, for health, for children, for pets. If you have nowhere to go, the sheriff will be there to keep the peace, to remove people from the property and hand possession back to the landlord. But just keep in mind that it has to be the sheriff doing this. It cannot be the landlord or his buddies. So this is what the end of the eviction process would look like. So what I had just mentioned about this process can only be done by the sheriff. Let's say while you're going through the eviction process, the landlord commits what's called a prohibited practice. A prohibited practice is governed by Florida Statute 8367. And what it says is the landlord cannot directly or indirectly prevent access to the unit, turn your power off, turn your water off, or cut utilities in general. If they do, then the landlord has committed a prohibited practice under the law, and the tenant is entitled to 3 times the rent in damages. So that means that if the landlord tries to circumvent this eviction process, this removal process, which is required to go through the court system, the landlord tries to jump that or skip, this entire process, then you, the tenant, would be entitled to sue the landlord for 3 times the rent in damages, which is a very powerful thing for tenants to do when the landlord has unfortunately committed one of these prohibited practices, which unfortunately we do see pretty often. So the last thing, that's kind of all the entire process for evictions. The last thing we're going to touch on today is security deposits. A lot of people have questions about security deposits. What I want to make clear is that our office does not handle security deposit cases, but we have a pro bono clinic where we have pro bono attorneys come once a month, and they will provide advice and assistance on preparing security deposit filings and stuff like that. And that clinic will give you a packet for you to take and file your own security deposit lawsuit if it's determined that that's in your favor. So the security deposit you pay before you move in generally. The tenant is not entitled to that security deposit until after they have left. Once the tenant has left, you need to provide a mailing address at least 7 days before moving out, or as soon as you've left. You need to provide some kind of mailing address. You need to request the security deposit and say, I want you to return my security deposit in whole. The landlord has to return the entire thing to you within 15 days. If they don't, then they have 30 days to tell you what claim they made on it. So whatever they've deducted from your security deposit. And that has to be done within 30 days of the move out. If there's no claim made within 30 days and you've sent your security deposit request, then the landlord cannot make a claim on the security deposit anymore. This is what a security deposit notice might look like. So when you move out, the landlord may send you a notice and say, hey, this is what I'm taking out of your security deposit for XYZ damages. And I want to make clear that it has to be for damages to the unit. Wear and tear in the unit just from living and scuff marks and stuff like that, that is not damages to the unit. So if you think that there's a dispute to your security deposit, raise it with us, and we can either provide you advice on it or, set you up at our pro bono clinic. If you receive that notice from your landlord, you have to object to it or dispute it within 15 days of getting your landlord's notice. If the dispute is ongoing, you say, I don't owe you this much. He says, you owe me this much. That dispute has to be handled in small claims court. So that is what our pro bono clinic would assist in preparing, is the documents that you would need to file in small claims court to obtain your security deposit. So that is all of the information that I have for you guys today. I know that was a lot, so I am ready to hear questions that you guys may have. And I'll stop sharing now.
Thank you, Alexis.
Very welcome. Okay.
So we do have the Q&A. Please review them and please do read them, the ones that you want to answer or can answer, really, based on the information available. Read them out loud since people can't see them.
One of these questions says, I am a Section 8 landlord. Will I benefit from this webinar? Absolutely, you will. So while we did not go into Section 8 specific rules, these are rules that all landlords should know. Like I said, these are the floor that every landlord, regardless of what program they're in, they should know about these rights, because a Section 8 landlord who commits a prohibited practice, it's still the same prohibited practice. I do believe that these slides will be shared after the presentation. Is that right, Alejandro? Okay.
Well, this video will be shared.
Okay.
Yeah.
What happens if the written 3-day notice is incorrect? For example, stating more rest past due that the landlord received and confirmed receipt of payment, and the landlord continues to file the complaint. If that happens, that you've already paid it, then you have the best defense in an eviction, and you would raise payment, and you would say, I already paid this, judge. I don't know why we're here. And what you should do at that point is say in big red letters, I already paid this. And then you need to attach proof that it's already been paid. At that point, the court will probably dismiss. So that's how that would work. Blake, do you want to take this one? This says, how are oral leases treated and how would it hold up in court?
Yeah. So I believe we spoke a little bit about this already, but when an oral lease is agreed upon, so you and your landlord agree verbally to a lease, um, it is treated as valid by the law in Florida. What I can tell you is when it comes to how it holds up in court. Um, Basically what happens is the judge will listen to both sides and make a determination as to who is more truthful, who they believe is more truthful. So, you know, they will weigh basically both sides' testimonies and how they see the oral lease and make a determination as to who they believe is being more truthful in their assertions. That is pretty much why we say it's better if it's written. Um, when it comes to my own personal practice, when it comes to creating things, I would say if it's not written down, it didn't happen. That is something that, has always stuck with me. So I would say that's probably a good idea for verbal leases as well. So, if you do enter into a verbal lease with your landlord, say you come to an agreement verbally, I would say as soon as possible, try to get it down in writing as well. So, you know, it may, your first agreement may just be verbal. Um, you know, just try to get it down in writing, just that so you have a record of it that you can uh go back to with them.
And more practically, if the landlord is filing a lawsuit and the landlord is not disputing that there's a landlord-tenant relationship, the court's not going to dispute it either. So it'll be treated the exact same. Subject to what Blake also just said. Um, there's another question that says I'm facing an eviction that I was served January 1, 2026. I'm a month behind on rent that I was supposed to make through the court registry. Will I get in trouble for making the payment next week? What I will say to that is that is a lot of personal facts that instead of answering here, I would encourage you to come to our office so we can take a look at exactly what's going on. Here's a really great question about how long does it take from eviction, the non-payment, to sheriff showing up at the door in Miami-Dade County, assuming no money or response is provided. So this unfortunately happens a lot where the tenant is given a notice, the notice expires, landlord files the eviction, tenant gets the eviction, is served with it, and ignores it for one reason or another. If no response is put in there, no one is contesting it, and there's essentially like no involvement in the case. I don't have the actual statistics, but in my experience, it could be as quick as like 30 days. If you just file your answer, if you just file something, that can make the process a little bit longer. Evictions are governed by what's called summary procedure, which is fancy legalese for evictions are on an expedited schedule. So regular lawsuits, you usually get 20 days to file an answer. In evictions, it's 5 days. So the process goes a lot faster than normal lawsuits. On average, I would say that if you're at least responding and involving, or you have an attorney involved, it could take the process maybe 90 days, 6 months sometimes, depending on how strong your defenses are. This is another great question. If you file a motion to determine rent, do you still have to deposit in the registry the amount in the complaint? So what I will tell you is that this is dependent on the judge. Our office would say that if you have filed your motion to determine rent, you have complied with the statute. The best practice is to do, if you can do 2 of those 3 things where you can deposit and file your motion to determine rent, you're more likely to be given that hearing. So if you can, I would say yes, go ahead and deposit. But if you only file your motion to determine rent, logically, you're asking the court to determine how much rent you owe. So you technically don't really know how much to deposit until the court has made that ruling. So if you can deposit, if not, your motion to determine rent is technically satisfies the statute. Um,
Uh, I do see the question about how long does it take from eviction to sheriff showing up at your door. So once that writ of possession is executed by the judge, the sheriff will post on your door. They can come within technically the next 24 hours. So there's a 24-hour period that passes by, and the eviction process takes place then. One thing that I do have to say is in Miami-Dade, our police officers do have quite a bit on their tables. So they oftentimes we do not see them show up within those 24 hours. It typically will take a couple of days, but they can show up within that 24 hours. So you should be prepared for them to show up in the 24 hours. But, you know, sometimes it takes them 3 or 4 days to do so, and, that's just based on, their capacity as well in terms of what they're able to deal with.
Thanks for catching that, Blake. Um, okay. So the next one, which is a great question, is can you please revisit the difference between a 1 and a 2 count cause? Blake, do you want to take that?
Yeah, so the difference here is, um, when you look at, 1 or 2 counts, the first count is always going to be regarding when we're talking about eviction, is gonna be regarding possession. Um A possession count, that's the one that we were mostly talking about today. That's on what I would call a summary procedure timeline. That's the 5-day timeline. That's the 3-day notice that you see. What I can tell you is that's regarding just possession of the property. That's not regarding money damages. The second count is the damages portion. So that's where they're asking for money. So, say they're accusing the property of being damaged, or they're trying to get back rent because they say they have been personally damaged in some way by the non-payment. That would be the second count. Um, Oftentimes we see first count alleged. So, the possession one at our office. We do see some 2 count causes, but oftentimes I would say, uh, they're looking for possession first and foremost. And if they fail to uh, state damages, so they fail to state that cause of action, they can't allege it anymore once an answer has been filed. So.
Great. So, by selecting my case to be decided by judge or jury, how much longer does it take for a decision? Um, decision. I'm interpreting this to mean like a trial. Um, Final hearings with the judge can be very quick. It's whenever the judge's calendar is open, which could be some judges are a lot busier than others, so it could be within the week or the month that you've had the rent determination hearing. Um, or it could be a month or so out. It really just depends. A jury is going to take a little bit longer. But the next question that we have is, does the jury request cost more money? It doesn't cost any money to request the jury, but it does cost money to have a jury decide. And again, you're only going to see the jury trial or the bench trial if you get past rent deposit, impasse fails, or I'm sorry, mediation fails, and then you're going to the trial. So it does cost money to have a jury. It does not cost money to request it, though. Another great question. If the court decision goes against you, are you responsible for court costs? Yes, you are. So that is why it's really important that even if you don't have strong defenses, still come to us, because what we do day in and day out is we can negotiate a move out agreement where you're not responsible for those court costs or attorney's fees if they have an attorney. Um, we can negotiate other instances where those costs are not put against you. But if a final judgment is entered against you, you are responsible for the fees and the costs. And so what that means is attorney's fees if they have an attorney. Costs mean the filing fees, the cost of hiring the sheriff to come out. That's usually about $100-ish. It could be up to $1,500 if the landlord wants to expedite it. So that is a risk when you go through the eviction process. But again, that is different than the damages. So damages, like Blake explained, is for typically back rent. This is separate from that. They can get costs for the possession count. Okay.
Did you see the partial rent payment
Oh,
question? That's a good question. So
good.
if a tenant offers a partial rent payment during an eviction process and the landlord accepts it, that's grounds to dismiss the action because the landlord is accepting rent at that point. They're no longer doing the eviction, and they can't assert both. So you need to, if you offer the landlord rent and they accept it, just be aware of that. That they're making acceptance of rent at that point. They're not able to move forward with that possession.
That's typically what we see under the statute. If the landlord accepts partial rent and the eviction process has already started, the landlord is supposed to give you an amended notice with the new amount. So if they don't, then yes, they have waived their ability to move forward with this eviction. The other thing they could do is also take that money and deposit it into the registry as well. So a partial payment, they either waive their ability to move on, they need to give you a new notice, or they need to take the money you gave them and deposit that into the registry. Okay.
So when it comes, I see a question about who removes the possessions during eviction. So if it's the sheriff executing the eviction itself, they will remove you, and your landlord is allowed to, after the sheriff removes you, because the landlord is not allowed to do any of those actions themselves, they may remove the possessions during the eviction process. So they can move everything out to, say, the yard out in front or to the side of the road. That's within their abilities at that point. So, if a writ of possession has been entered, um, you know, I would advise you at that point to just make sure every possession that's valuable to you that, you don't want damaged, that you have uh, probably stored and close by you just in case, because you know the landlord is under no obligation after the sheriff executes the writ to treat your possessions with care. They can throw them out at that point.
And then as far as pets, if there's a pet there and you're not there, you don't have to be home for them to do this. Um, if there's a pet there, though, that pet is typically taken to the shelter. So as soon as you get that 24-hour notice, that is the time that you should be making decisions on where to put your irreplaceable things and where your family, children, pets will be going, so that you don't lose those things. Does legal services keep records of evictions in the county, such as numbers and areas? We definitely do. That is one of our big priorities at legal services. We provide our annual report every year. I believe it just came out. It can be found on our website, but legal services serves Miami-Dade and Monroe County. So it'll be for both of those counties. I don't know the difference in the numbers off the top of my head, but I know that we do have that information if you're interested in it. Um, in prohibited practice, does it matter whether the FPL shutoff actually happened versus was attempted and stopped in time? They started a stop of service, but it was stopped before the shutoff. So it does matter, unfortunately. If it wasn't actually shut off, it's probably not going to arise to a prohibited practice. The reason why is because the judicial system is a reactive system, not unfortunately a proactive system. So unless the shutoff has actually happened, it's probably not going to arise to a prohibited practice. But if a prohibited practice or if the shutoff happens later on, then you can bring up the fact that they've attempted to do this in the past as further evidence that this was intentional. Um,
I just want to say, Alexis, I want to
Sure.
respect both of you and Blake's time. I'm happy to continue. I have no problem. I know we still have a good chunk of folks, but I want to respect your time. We need to close. I know it's 1. Let me
sure.
know if you'd like to continue. Let me know. I'm happy to do both.
I'm happy to take some more questions. Are you good with that, Blake?
Yeah, I can take some more of it.
Yeah,
Perfect.
I think
Thank
that these questions are really important and really great questions. Like this one says, is there anything that protects persons with disabilities from evictions? No, unfortunately. Um, Once the writ of possession is posted and the sheriff is there, even, bedridden people who have nowhere to go, there's nothing that prevents the sheriff from removing them. Is there
And
any
now there are services for people with disabilities.
Right.
So if you are facing the eviction and it's going to be executed, that's something that I would say get into contact with those services, and they will you know if you contact our office, we can provide you a referral to those services, so you can really no get that addressed, because if you are facing a disability and say in the example Lexus provided are bedridden, obviously that's something that we especially don't want to see. You face homelessness in that case, so just because of the consequences there. So
um what if you live in a condo or HOA and they want the homeowner's tenant to move out due to violation? That is very fact specific, but what I will say is we do see a lot of condo, HOA evictions, mobile home evictions, co-op issues. While those are not governed by Chapter 83, it is something that our office handles and deals with. So if anyone is facing the eviction, come to us. I actually see 2 of these questions. It says, is there anything a person can do once an eviction is on their record to remove that eviction from their record? So I want to make a very, there's a very nuanced difference here. So an eviction judgment is when you lost the case. The eviction judgment is that harmful judgment on your record. That's the thing that we will work to try and remove from the record or prevent from getting on your record. The filing of the actual lawsuit we cannot remove from public record. It is something that we have tried to do in the past, but unfortunately, we've had several courts come down and give decisions that because those lawsuits are matters of public record, they cannot be removed. They cannot be expunged, essentially. So the filing will stay public, but the actual eviction judgment we can help remove before or after the fact.
and one thing to clarify is they filed an eviction action and decided to dismiss it because you either settled with them or there's no more cause for action. It will show that it was dismissed, and as it is public record, we live in Florida. Florida has something called sunshine laws, which basically means we have more public record than other states. What I could tell you is I'm originally from Michigan, you could get an eviction sealed on your record in Michigan. Can't in Florida. That's just unfortunately the case here. So that is something that, we've tried in the past, but the courts have found that it is a matter of public interest, it is a matter of public record. So they will keep them open.
I see a couple of questions about I got a notice and I paid for some of it, but I'm still behind. Um, the landlord is required to give you an updated notice with the updated amount. I see a couple of other fact specific questions. Come to our office so that we can kind of figure out what's going on. Who pays eviction fees in an eviction, tenant or landlord? Like,
Can you repeat that again?
yeah.
Sorry.
Who pays eviction fees, the tenant or the landlord?
So that depends, honestly, whether or not a judgment was entered. But in terms of filing fees and all that, that's going to be the landlord, unless they specifically assert that they're asking for fees and costs as it relates to the claim. That is something that they're entitled to do, but they don't always do. Especially, I will say, if the landlord is not represented by an attorney and it is a pro se landlord, most often you will not see that be certain.
Um, okay. But if you get the eviction judgment, the tenant is required to pay the fees and costs. That's the only exception there. This is a really great one. What happens if your lease expires and there's no other agreement, but you continue to pay rent? What happens when it happens all the time, right? You move into a property 20 years ago, you had a lease when you moved in, you haven't signed a lease since then. What happens is in the state of Florida, once your lease expires and you pay the rent, you automatically convert to a month-to-month tenant. And what that means is if the landlord wants to end your tenancy, then they only have to give you that 30-day notice. So that is why having a lease is really important and really beneficial and protective for you, because with a month-to-month tenancy, whether or not, if they file this eviction and you win, right? If they filed a non-payment eviction and you win, but you're a month-to-month tenant, well, all they have to do now is give you a 30-day notice to terminate that month-to-month tenancy. So, really great question. In cases where tenants withhold their rent due to serious habitability or maintenance issues, or when they believe the landlord is claiming charges that exceed what is actually owed, what remedies are available to the tenant? What documentation should tenants gather, and what steps should they take before the eviction is filed? So when there are serious habitability issues, the statute allows you to serve what's called a 7-day rent withholding letter. What that means is you have to give the letter to the landlord and it says, these are the repairs I want you to make, or that I'm demanding that you make within these 7 days. And if you do not make them, then I'm going to withhold my rent until the repairs have been made. The catch is that the landlord can still file a non-payment eviction. If that happens, you would raise your letter as a defense. What you should do as far as documentation is have it in writing every time that you have requested something to be fixed. Keep receipts of things that you've had to buy because of the habitability issues, right? If your fridge doesn't work and it's spoiled, you can keep your food receipts. Any conversations that you have with landlord trying to work with them to get these items fixed.
I see a question as well regarding whether or not our office accepts walk-in clients or is an appointment required prior to visiting the office. So every Monday and Wednesday we have walk-ins. That typically is from when our office opens till noon. So you know one thing I'll say is try to get in earlier rather than later regarding walk-ins. We also have a number that you guys can call, as well as you can email our offices regarding your issue and speak to in someone in our intake department, and they'll be specifically able to help you. They'll take down your case and then they'll refer it to another one of our units, and typically we'll see if you need brief services and an investigation, or it gets referred to people such as our department where we handle evictions.
I accidentally skipped over another really great question. It says, does this presentation apply to squatters? No. So squatters is the legal term for squatters are unlawful detainers or transient occupants, which is governed by Chapter 82. Chapter 82, or people governed by Chapter 82 do not have the same rights as Chapter 83. So 83 is for a landlord-tenant relationship only. Can the sheriffs defer to a local police department to execute the eviction, like the City of Miami Police Department? No, it's court staff, it's court sheriffs that handled the actual removal. Like, if you see any that you'd like, there's a couple of questions in Spanish, and I apologize, I don't speak Spanish. So Alejandro, if you do and you can translate, I'm happy to answer those as well.
So I see a question regarding using Zelle. So if your landlord is accepting payment or rentals payment via Zelle, or I'm thinking of the other ones, Cash App, Venmo, any of those services, that still acts as an acceptance. One thing I would say is when you pay it, there's a little section that you can add that called memo, and you just put in the memo what the payment was for. So so that way, if there's a dispute whether or not the Zelle payment was for rent, you can go back and use that receipt as basically a way for you to state, hey, this was for rental payment, and they can't assert, oh, this is for you know anything else that would be a piece of evidence that you could use.
And I paid my rent through Zelle. So, and I do exactly what Blake is saying. I put the memo line for the month it is. If the landlord did not want to accept the Zelle rent payment, they would need to send it back to me. Or if there's an eviction going on, then they would need to give that updated notice or put the money in the registry. I see.
Alexis, I see
Yeah.
you mean the questions in Spanish.
Yeah, go ahead.
One of them is asking, they're a renter for 10 years. And what can she do if the owner doesn't fix damages inside the house?
Same habitability issues. If they're serious, then you give that 7-day rent withholding letter. That's another thing that my office can assist with. We have pro se forms on our website and that we can provide for you. So I would encourage you to come to our office still. And we can give you those forms or you can find them online.
Okay, so I think for questions in Spanish, para preguntas en español, what we'll do is at the end, al final, whenever I send that email with the contact information, al final mandaré el correo electrónico con toda la información de contacto, and then one of your Spanish team members can respond.
Okay.
Y así el equipo de Alexis y de Blake, una persona que habla español, puede responderle a ustedes en español. I think that would be the best.
Okay, perfect. So we're almost at the end. So there was a series of questions about how to apply for our services. So great question. So like Blake mentioned, we have walk-in hours every Monday and Wednesday from 9 to 12 p.m. You can come to our office and you will meet with someone right then and there and get advice and services. If no one's available, you'll get a call back within 24 hours. You can also call online or call during our phone intake hours. You can apply online, submit right online. All of these options are listed on our website. So if you go to legal, I think it's lsgmi.org. If you just type in legal services of Greater Miami on Google, it's the first link. The first thing you'll see is apply for services. If you click on that, that will show you all of our intake options. There are certain eligibility requirements that we have. Because we are a nonprofit organization, we can only assist with people who meet a certain poverty guideline. But instead of explaining that to you guys, come to us and let us figure out whether it's something that we can assist with. Because if we can't, then we have our partner organizations that we can send you guys to instead or provide you resources. So I would say apply if you have a question and we will answer it there. How long do people have to deposit into the registry? The same 5 days you have when filing your answer. So when you get served, the same 5 days that you served, when you file your answer, you file the motion to determine rent or deposit in the registry. It's the same timeline.
And something regarding that, whenever rent becomes due, so if you pay on the 1st of the month or the 3rd of the month or whatever day of the month it is that you pay, you have to pay again into the registry what your amount, your rental amount is. If you don't, that becomes an issue in itself. So you want to just make sure that you are current with that and still doing that. That's very important.
And that's a great point that I don't think that we emphasized during the presentation. Not only is the rent alleged owed into the registry, but it's also rent as it becomes due. So if an eviction starts in June and it's asking for the rent through June, now we've moved into to July, you are then also required to deposit July's rent into the registry and so on and so forth. How does an eviction filing affect your ability to rent another dwelling versus removing the eviction from your record? Well, if you have an eviction judgment on your record, some landlords may not be willing to rent to you because they might think that you're not a credible or stable tenant. And so that's why we try and do everything in our power to set you up for success so that you can find new housing and create that new stable lifestyle and housing for you without having that issue following you. What methods are acceptable for a 30-day notice to a tenant? For any notice, it needs to be written and it needs to be either hand delivered or posted. There is a new law that went into effect in July that says landlords can email the notice. However, the tenant has to voluntarily agree to receive emailed notices. So it can't just be, hidden somewhere in the lease. The tenant has to agree that they will accept the notices via email. And the tenant can opt out of that at any time. So practically and generally, though, it needs to be written and either handed or posted, just like the complaint. So I think that was all of our questions. That was fun rapid fire trivia. If you guys have any other questions, please feel free to let the commissioner's office know. I know that they will provide this presentation, this recording, and our intake options to you guys as registrants. And thank you guys for your time. I appreciate it. And again, my name is Alexis. Please feel free to contact either Blake or myself if you have any questions.
Yeah, I hope everyone has a great rest of your day as well.